Hey everyone, this is Carl Carpenter here with you again from Arrakis Consulting, and we're going to start our next episode for the little video webinar series that we're doing. This one's going to be what is privacy? And just like the rest, it's going to be super high level, just to give you a rundown of what could happen, what is privacy, other aspects to think about, how they interrelate with other areas of cybersecurity or other areas in general and so on. Again, idea is not to have a long conversation about this. We're going to get in the weeds on other privacy-related material later on, which could be anything from HIPAA to GDPR to CCPA, or maybe all of it. Who knows? So the first thing we want to cover is exactly what is privacy. Well, privacy is somewhat relative in relation to how it's viewed. So, for example, in a general sense, privacy is viewed as something that's classified by a government entity of some sort as sensitive, and where that information belongs to an individual, a human being. That's one respect of privacy. Another aspect of privacy is from one company doing business with another company. So while you may not have regulated information being shared by a company to another company or a person to another person, that person who owns that data still views it as sensitive information or confidential information. So in relation to privacy in a holistic sense, we generally view that as information that's regulated by some law somewhere, like HIPAA or PCI. Well, PCI is not a law, but HIPAA or FERPA or COPPA or something like that, as opposed to just sensitive information in general. So it's super important to understand that privacy-related information, when it's regulated by a law, that's a federal thing that you have to deal with. That would be a law, and confidential information would be something that would be governed and controlled by a contract or an agreement. However, the intent behind privacy is exactly the same, regardless of what it is. It's just that one you can go to jail for and get fined, and the other one you can be held liably civilly or possibly criminally based on how bad it is. But it really doesn't matter in the end on what it is. It's just that the idea is that you have to keep things private. So, however, it's important to also understand that in some cases, companies may not truly understand the concept of privacy. Or maybe they do truly understand it, but they're not willing to fully accept it. More than once, here at Arrakis, we've run across companies that have said they want it to be completely private, they want to be completely secure, protect their customers, things like that, and so on. But it was really just words. They didn't really do that. What they did do is understand that they had a product or a service or whatever that had a very high profit margin attached to it, provided there was no aspect of actually enforcing privacy or being compliant with privacy. Because once you actually do what you're supposed to do in relation to privacy or confidential information, then that severely can severely cut into the profit margin. So unfortunately, the concept of privacy kind of varies in relation to who you're talking to, but it also varies in what companies plan on doing to enforce privacy. So, how long has privacy been around? Actually, a very long time. Back amongst the Greeks and the Romans, they were talking about privacy. Obviously, we don't care about what the Greeks or Romans did back in 10 BC or whatever. We care about right now. We care about the laws that are going to affect us, right here, right now. So essentially, privacy was first brought up in the mid 60s, and it had to do with contraception. In relation to contraception for a specific state, the Supreme Court got involved, and so on and so forth. But it wasn't really enforced until the mid 70s, which is kind of surprising to think that privacy wasn't really considered until the mid 70s. You'd think it would be considered a long time before that. And the original intention of the privacy regulations from the mid 70s was to prevent government overreach. And again, if you think about it, back in the 60s, 70s, contraception may or may not have been a law, like whether or not you can sell contraceptive items to a couple or not, that were or were not married. The government may have had some opinions on that. So the idea, back then in the 60s and 70s, was that the government really shouldn't have an opinion on the usage of contraception, way back when. And the Supreme Court agreed with the case that came forward. But obviously, so the initial standpoint was the government overreach, what the government could see or know or do. But obviously, privacy laws have since been utilized in more than just the government. So we have cases where, companies are now subject to privacy law, or doctors, or, well, still the government, but definitely companies that, might have some sort of privacy aspect to it. So it's also important to understand exactly what is viewed as private information, because it changes. That's it in a nutshell. It changes. So, for example, you could have privacy-related information that is health-related. You could also have privacy information that is financially related. You could also have privacy information that is viewed as acceptable in the United States, but not acceptable under European regulations. So it's super important to understand the aspects of privacy as it applies to you or your company. It's also important to understand, in relation to privacy, that it's not the same based on your age. So, for example, while medical information is private regardless of how old you are, certain information in the United States is more private if you're a minor as opposed to an adult. So the older you get, some information may be less sensitive, as opposed to being more sensitive when you're a minor. So it's super important to understand, based on the age of the information, or based on the age of the data subject owner, for the information you have on that person, on whether or not it's actually regulated or not. Here's a good example. The Yellow Pages has it in the telephone book. The Yellow Pages, it has a name, first name, last name, address, and phone number. Totally fine, but you might not have realized that those are all adults. So in most cases, in fact, I can't really think of a case where you would have a child as a legitimate entry into the Yellow Pages as a child, as a minor, and not be breaking the law. I know in Arizona it's certainly a serious incident to publish minor information, and I do believe it's a federal requirement as well. So there is a common phrase that we use here at Arrakis. I use it all the time. It helps make the point whenever we're talking about privacy. And it's super simple. And the phrase is, you can have security without privacy, but you can't have privacy without security. And the reason why is because we're pretty much in the 21st century now. There's a lot of technology going on in the 21st century. And as a result of that, keeping information private is almost in all cases going to depend on some sort of technological advantage to keep that information private, whether it's encryption or secure email or some sort of method of transferring files in a highly encrypted manner, or maybe tracking who opens a file, who closes a file, so on and so forth. That's something that's going to come into play. The end result, though, is that technology is a part of everything nowadays, and you cannot have privacy without security. but you absolutely can have security without privacy. So what does that mean? Well, essentially, what that means is that in order to have true privacy for information, you're going to have the appropriate technology in place. You're going to have to make sure that technology is engineered and architected in such a way that it supports privacy or security of the company. And you're also going to have to ensure that you have experienced uh, technical and privacy people that understand what's going on to help monitor the environment. That doesn't mean that you can't have um, more technical on the monitoring and less technical on the privacy side, but you're going to need to have the right kind of people uh, to monitor the environment. In GDPR, you have a data protection officer. This is a required role in GDPR, and one of the main purposes behind that is to help ensure privacy. So, does this technically mean that every single privacy person should be a technologist of some sort? No, not really. You can have privacy people that have no idea, how to spell IT or technology in general. But a privacy person who has more of a technology background is probably going to be better off than a privacy person who doesn't, because they simply can ask questions and understand those things better than somebody who doesn't have a technology background. It's also not unreasonable for, depending on the size of the company, it's not unreasonable to figure out, like, hey, this is a small company, so the IT guy might be the privacy guy and the security guy all at the same time. That's certainly not unreasonable to run across, and it's unfortunate to think that, but it's also not a good idea. What you really want to do is segregate those roles in between, people who are security people, who are technology people, and who are privacy people. What you want to do is avoid having a situation where you have one role that does all of it, but then there's a privacy situation, and the person who should be protecting the information is also the person who cares about the privacy, and then that person, for fear of losing their job, essentially doesn't bring anything up. So the more you can segregate the roles, the safer your company is. So, what could happen in a privacy situation? First off, let me just blankly or bluntly say it: nothing good. There's nothing good that's going to happen out of a privacy situation. It's either a situation which is nothing good, or there is no situation, and everybody's doing their jobs and things like that. But let's just say there is a privacy situation. So what could happen? First off, you could have companies or people that could be held accountable and face sanctions of some sort. So these sanctions could be fines, civil and criminal charges applied against them. So literally, people could go to jail. You could have reputational aspects of this things. The negative publicity out of it could be a killer for the company. It could greatly reduce the profit margin. While Target, we talked about Target in one of the other webinars. I think they lost like 46% of their revenue in the year that they had the Target breach. And a large majority of that is because of the reputational impacts. However, there's also other things that could happen. Let's say there's something so egregious that, a person screwed up so badly that, they could be banned for life from the industry that they're in. So put yourself in the shoes of that person. Imagine going to university, learning, studying, doing all that work, spending 10, 15, 20 years in an industry doing whatever, and then as a result of your negligence or as a result of mistakes, that you're banned for life from that industry. So these things can happen, and they've been known to happen. Another thing that could happen, and we talked about this in another webinar, I don't remember which one, was that situations can follow you. So just because you have a privacy related situation in one company and you say, oh, I got caught, I made a mistake, all right, I'm going to resign and go somewhere else, that doesn't mean that that situation can't follow you to the next company or farther on down the line. Unfortunately, there have been cases where people have moved from one company to another and they've ended up, having to deal with it even though they've moved on. Other areas of that we've run across in the past for that we've heard from other companies is we're a startup or we're a small business. It's important to understand the law is the law. They don't care if you're a startup. They don't care if you're a small business. There's no business environment that allows you to violate the law just because you're a startup or just because you're a small business. It's kind of like if you were a car manufacturer, you made vehicles. You made four-wheel vehicles, and it doesn't matter what they are, but you made a vehicle, and you're a startup or you're a small business making a vehicle. Just because you're a startup or a small business making vehicles, making cars, that doesn't mean you can't put a seatbelt in the car. That doesn't exempt you from putting seatbelts in cars. So it's kind of like that, but for information. So it's important to understand that if you're a startup or a small business and you can't do something, then you need to figure out how you can do it as fast as you can, because once you have a privacy situation, it doesn't matter if you're a startup or a small business. They're going to come after you, and it could be pretty significant. So laws, based on whatever business you're in, laws do require that you understand and accept the responsibility for being in that business. And if you're not capable of accepting that responsibility, then you might want to reevaluate your business. So, what has happened in the past? Well, I'm going to just be honest with you here. I'm going to pick on Facebook a lot. So Facebook, as of the time of this recording, Facebook has accrued over about $700 million in fines relating to GDPR alone. So that's pretty significant. And a lot of this has to do with, actually all of it has to do with privacy. And it could be something as simple as opting in or saying you're going to do something in your privacy policy but then not doing it, or saying or doing something that isn't disclosed in your privacy policy. It could be anything. So it's kind of universal, but literally in the last 2 or 3 years as of this recording, Facebook has around $700 million in fines relating to GDPR alone. And GDPR is one of the popular privacy related regulations that are out there right now. We'll talk about them, or about GDPR, in a much more detail at a later date. But it gets better. So we're looking at almost $1 billion in fines for Facebook. The FTC, Federal Trade Commission, fined $5 billion to Facebook as well. So here we have almost $6 billion in fines that is a result of some sort of privacy inaction. So that, to me, that's pretty significant, and I hope people are understanding the significance of privacy-related activities and why it's important. Now, does that mean that Mark Zuckerberg is not going to utilize every possible legal avenue he can to get out of paying $6 billion in fines? Sure he is. I mean, who wouldn't? I would expect him to. But the reality of it is he's still going to pay some fine. He may reduce from $6 billion to something else, but he is still going to pay a lot of money in fines. And it's all because of privacy and how they did things and how they should have done things better, how they viewed the profit margin as more important than the legal aspects of what they were doing. And it's all coming down to it. And this is all stuff you can Google and see for yourself. All right, so what regulations are in place? Now, this is specifically for the United States, with the exception, I'm going to bring up GDPR, which is European Union and the UK. So, in 1974, we had the U.S. Privacy Act. Well, that was kind of just PII in general. You know, it is what it is, just protecting personal information. Then we had student records come in 1974. That's actually in the same area and under the same pretense of protection of the PII. Unfortunately, back in the day, you could request student records without the student actually knowing about it. Well, now it's the other way around. We also have HIPAA, which everybody knows. That's medical records, health-related records. Honestly, it's kind of surprising that they didn't think that medical records would be important until 1996. It's kind of strange that it took 22 years for them to figure out that medical records were just as important as student records that were uncovered 22 years earlier. Then we also have COPPA, which is records relating to children or children or child records that are online. And again, much like HIPAA, we figured out student records in 1974 were important, and then we didn't figure out that child records were important until 1998. Of course, the internet has something to do with this as well, but it doesn't change the fact that it appears as if you just look at the dates alone, it appears as if some of our lawmakers were looking at issues and situations and creating laws, and then they took a nap for 22 years. That's just math. It just appears that way. It could be wrong, been wrong before. Then we have GLBA, 1999. That's for financial records, so banks and credit card companies and things like that. That's the Gramm-Leach-Bliley Act, for financial records. Now we have GDPR. This is where things really changed. GDPR is a European regulation for the EU and the United Kingdom that has a different definition of what is protected. So, for example, in GDPR, if I can take an IP address and associate it with a human being, like a static IP address associated with a human being, that is a protected record. Geolocation. If I can associate a geolocation with a human being, then that is a protected record as well. So then it's also important to understand that at one time the European Union and the UK were together, and then the UK separated. As a part of that separation, GDPR, there's a European Union version and then there's a UK version. So when they separated, the UK had their own version of GDPR, which is commonly called GDPR/UK. But it's kind of the same thing. But if you go think about it, if I was to talk about GDPR, and we will talk about GDPR in much greater detail, if I was to say that geolocation information, if I could track that down to a human being, was a protected record, makes you wonder about the phone book again, because to my knowledge, phone books have the name, address, and the name and address of a person, which kind of counts as a geolocation record. So there's quite a few things to think about in relation to GDPR and how they can affect people. We also have the CCPA, which is the California version of GDPR. There's some changes in that. So the California version of GDPR has comments and statements around households. GDPR does not have a comment around a household. It has comments around human beings. CCPA has comments around household, like an actual address, and everybody who lives at that address. Now, I'm not going to go into all the other states, but there are, as of this recording, a total 5 or 6 states out there that actually have their own privacy information, data protection privacy acts going on. So as time goes on, we'll see more and more privacy related information or regulations that come out that that we have to comply with. However, if we're in the federal government and we have a very, I don't want to say lax, but a less than ideal privacy law, which would be from 1974 or FERPA, HIPAA, COPPA, or GLBA, and then we have the European Union that's coming out with GDPR in 2018, and then as a leader executive on the executive staff of the federal government, we see that all these states are coming out with their own versions of privacy laws. Then it only seems natural that at some point the federal government's going to have something similar to GDPR. Now, obviously, a lot of this is politics. That's thing one to remember. Obviously, a lot of these laws that are coming out are specifically designed to generate revenue in the form of taxes and penalties and fines for either the states or the federal governments. But it seems logical that the federal government would, at some point, want to have its own version of GDPR. So that is the case. It's the American Data Protection Privacy, or American Data Privacy and Protection Act. I call it ADAPA. But essentially, that is the U.S. version of GDPR, and it's not out yet, but it will be at some point. Hopefully, once it comes out, there will be less knee-jerk reactions from the states to create their own state-level privacy laws. So you may also wonder, why is all this happening? Why do we have all of these privacy laws? Well, the answer is simple. First, we have people making mistakes, or companies making mistakes, and not to point out Facebook, but Facebook it could be one of those companies that are making mistakes. And as a result of that, regulators and lawmakers and so on get involved. And then these lawmakers, because they want to keep their jobs and make their constituents happy, what they do is they start proposing laws, because that's what lawmakers do. They start proposing laws to help the problem go away. And as a result of that, we have all these new laws that are coming out, or regulations or whatever. In most cases, quite often, these laws or regulations are really nothing more than knee-jerk reactions by lawmakers and regulators that don't really know what they're doing or what they're talking about. And they're just hoping that they can vaguely meet the best requirements of what their constituents are asking for. And it's also important to understand that any of these regulations, the privacy, FERPA, HIPAA, COPPA, whatever, they're really the minimum standards of what it takes to protect the information. So you don't really want to, as a company, if you're saying, I'm compliant with HIPAA, well, you could be compliant with HIPAA, but you could also do a whole lot more and still be compliant with HIPAA, but a lot more secure, a lot more safe, protecting your end users' data more, things like that. But you just have to understand there's a cost and an effort to doing that. So it kind of depends. We always advise companies, before you enact something, understand the cost and the effort, and can you maintain it. If you can, then sure, do it. But if you can't, then maybe you have to figure something else out. And if you can't even come close to what you're supposed to do in relation to protecting information, then we'll literally tell companies, maybe you should figure something else out entirely, because you're violating the law, and we don't want to have to be in a position where we're associated with a company that is breaking the law knowingly. All right, and with that, let's wrap up for this video webinar, and I hope to see you guys soon. If you're interested, we have another couple video webinars. What is compliance? Which is about being compliant with either regulations or contracts or so on. And we also have another one like, what is cybersecurity? And we help explain that super high level, not designed to get into the weeds or turn you into like a PhD candidate on cybersecurity or anything, but just super high level, get in the weeds and see understand what cybersecurity or compliance is, and we certainly encourage you to do that. And as always, please subscribe to our YouTube channel. Leave comments, suggestions, likes, whatever, dislikes. Feel free. We got thick skin. Tell us what you think. If you have specific areas you'd like for us to cover, feel free to leave that as a request in the comments, and we will work on getting that out there so we can get more people involved. And with that, I thank everyone again for joining me, and I will talk to you next time. Thank you again.